Thank you. Good morning, everyone, and welcome back to the Teach Grant Subcommittee meeting. We made great progress yesterday. Hopefully, we'll continue to make great progress today. I hope everybody got home okay. Yesterday was snowing in places, some places more than others. Hopefully, then. Does anybody know Debbie? She's here, right?
I haven't seen her.
Okay. So maybe she's still kind of on her way. I just saw paper there, so I thought maybe perhaps. No, that was from yesterday. Oh, okay. All right, perfect. Well, all right. So I guess what we should do is continue our journey through our proposal. And then we do have the updates from yesterday, but I think to hold those for just a moment until we get through our first round of stuff, and then we can flip back to that. We have some meaty subjects today. I did want everybody to see, we were talking yesterday about the just sort of show and tell, and I'll pass, we have a couple of copies to pass around so you can see what it looks like. It doesn't, it's not like done this way anymore, but this would be what would have been if you had poked yourself into the website for this and saw a PDF. This would be the PDF of what the national teacher shortage areas national listings looks like. And you can see very clearly how it's put together and how the states think about these things. So I just thought I'd pass that around so you just have a sense of what it is that we've been talking about, and that it's not just some tiny little thing, and that you can hook back to whatever year that we need to hook back to and whatever. But this would be what the PDF. If you go to that same site, you can get the same PDF. But you can see why we didn't want to print a whole bunch of those and kill a bunch of trees.
And also, if you want to look at which schools and teaching positions are included, it's also available as an electronic report where you can search by year, by state, and then you can see how it's arranged on the digital report as well.
Good morning. Oh, glad you're here.
Does anybody have luggage or coats that I can store in another space? I know you guys are a little crowded.
Does anybody have luggage or anything they want to store anywhere else?
Or does anybody need anything that I can run out and get?
Seems like it.
Sure. Yes, but if you think of things that I can do, please let me know while I'm here, and if not, I can always
We have a very friendly crowd.
Well, I can tell from the report out that we had in the meeting too yesterday that you're doing great work and you're making good progress. So all I keep hearing about is that you have the best team. So
That's what I tell them all the time. I said, we're #1 team. She thinks I'm really serious. I've been saying this to people. But yes.
I just want to raise one other issue. So I was poking around on the TSA report, so the teacher shortage area report, and with some states it's listed as core education in a given grade would qualify, and so that would be different than the language that we have in the regulations, which would also be confusing. So it speaks to your point about how it's just not aligned. I also wanted to flag the student I spoke with who had the GPA issue and then had her grant convert. She had to drop out of her program because her grant converted. She reported it to the servicer. She was in qualifying employment and had her grant convert anyway. So it's just one more example where even if students are complying with their form submission, they're still having their grants convert due to servicer error. So I just wanted to clarify that because I had made an error yesterday and accurately represent what happened to her.
Does that clarify the case for you?
I think that's very different than what was described, and it's unfortunate for that student.
Absolutely. And along those lines, I also wanted to raise for the committee, I went back through the numbers of the wrongful service conversions, comparing the information that was provided in the 2018 Ed report, the GAO report, and then the public citizen report that was the byproduct of their FOIA litigation. There were, I even drew it out in a diagram, because I was getting a little lost in the numbers. And so you'll see my notes here. So when ACS was the servicer from 2008 to July of 2013, 37% of the involuntary conversions were due to servicer error. That's crazy high. So, and then when the GAO did their report, which where they focused in on involuntary conversions from July 2013 to July 2014, just in that year, there were 2,252 Teach Grant recipients that had erroneous conversions due to servicer error. We don't have, I have asked for the data, but I haven't received it yet about the continued servicer errors. But if you take that 1 year as an indication of what continued to happen with FedLoan as the servicer, then you'd have approximately 9,000 wrongful conversions from 2014 to the present. And so if you add all of that up, so 10,776 plus 2,252 plus approximately 9,200 errors, you have almost 1/3 of the 78,000 people that had their grant convert just due to servicer error. And that doesn't even include the people that submitted their form, had a problem on it, got it returned, and then had it subsequently rejected, and then got their grant converted. And so this, for me, at least made a little bit of sense, because I was like, why am I getting so many calls from folks who complied with the letter, or what even I would interpret as the letter of the law, and still had their grant convert? And it's because there's such a high rate of servicer conversion. And so I know we talked about this yesterday in terms of making sure that grant recipients are aware of the dispute process, but I know there have been a ton of problems with FedLoans as a servicer. They have a number of class actions proceeding against them. There have been a couple of cases that have been brought up by state attorney generals against them for their servicing errors, and so I wouldn't want to assume that those problems would be remedied, and I want to make sure that students know that they have recourse.
Kira, I think that's one of the reasons why I think we need to continue to put in there, if there's a service area, what the remedy is, but also the reminder of the suspension, which we're about to cover, right, as to an opportunity for those individuals to suspend their time so that they understand that they can still fix a problem before it is converted.
I totally agree, and I totally think that making the information as clear as possible will hopefully encourage more students to take advantage, because then there won't be the risk that their grant could convert, even if they did everything right. I mean, I've heard from teachers who have told other teachers not to take advantage of this grant program because they feel like it's not fair, that they will read the rules, they're trying to follow the rules, and they have their grant convert anyway.
I want to say thank you for doing some sort of back of the napkin calculations on some of these things, and I would second your request for more data from the department on some of these numbers. It would be really helpful to get a really clear picture of it, but I think you've done a really great job in trying to piece the puzzle together here a little bit, so thank you for that. I think that helps ground some of the work that we have to do.
Thank you. Other comments on this before we move on to our next section, periods of suspension?
I had one additional question. You can tell I was up late last night digesting what we had talked about, and I did want to ask who will be making, or who will be generating the the form where Teach Grant recipients will be reporting their qualifying service year.
Generating the report?
So generating the form that has to be submitted back to either FedLoan or the department relating to the service year.
So that probably would be an information collection initially, but who would actually, oh, I'm sorry. It would definitely be an information collection, but I think it would probably be generated through initially FSA, correct?
Well, we will, when you say generate it, you mean who's going to make it available and send it to people? That would be our Teach Grant servicer would make it available to people to download, but it'll have to be cleared through OMB, and that, like the agreement to serve, is something that we will work on in conjunction with this rulemaking, and there will be an opportunity to comment on that.
So in other words, just to sort of clear up, that for those that are unfamiliar with the information collection process, when we have forms that are filled out by the public, you sometimes will look at it and you'll see something that says OMB number, whatever the number is. That number is generated during the process of this information collection clearance process, where we have an information collection, whether it be an application, a form for filling out for whatever, it doesn't even matter. It will go through a clearance process through OMB where and us as well, but the public will have an opportunity to comment on this. So after the public comment period, after we've gone through again and we cleared it again based on the public comment, it will get a number and then it'll be an official form, and then at that point we can pass it off to who, like in this case, the servicer. But until that point, we have to clear it and make sure that. That's why I asked when you said generated, it was kind of a strange animal because it's more like that.
But the service year forms, the annual certification forms, and the 120-day notification forms did not go through the OMB process previously, correct?
Those, the ones that they are using right now, did not, but OMB's aware of that, and we're going to. But when we get further into these proposed regulations, you'll see that we're proposing to make some significant changes that would radically change the forms that are needed, and hopefully simplify.
And we will talk about that as we get
And I'm just really grateful that that will happen, because I hope that that will improve the clarity of the forms that Teach Grant recipients are being asked to complete.
Is it possible to get copies of one of each of those forms just to sort of see what they already look like? Because I have no idea.
I would recommend that we hold that request until after we go through the rest of this, because there's going to be reasons why you may not need all of that.
John, can you go over
Yes, which way? This way? Oh, there's another one right there. Take that one.
Okay. In addition to the forms, the servicer also sends out. I thought it is. It is
Yeah,
on.
it is on.
It is on. Yeah. In addition to the forms, the servicer, when they send these out now, they also send an accompanying cover letter. And one of the things that we are planning to do in the near future is undertake a review of that correspondence that the servicer sends out to try to make it clearer and easier for grant recipients to understand.
And I just want to flag for the committee that the GAO in their report did note that some of the information that FedLoan was sending out was wrong. And so for Teach Grant recipients, almost at every point that they've been getting these notifications, they've also been getting misinformation.
I'm curious if there's a possibility, I'm very familiar with this process, I know it takes a while. Is there anything that the department can do in the interim? I know you're undergoing these big changes, but are there things that are possible, because you clearly understand the challenges, because you're proposing a bunch, well, I know we'll get to whatever the changes are, but is there anything that can sort of be done in the interim for these Teach Granters? Because this could be until, next July 1 of next year at the earliest, and that's if there are no bumps in the road.
Well, the review of the notices that the servicer sends out, that's going to happen before then. So even that actually, I think, may be more of a problem than the forms themselves, that perhaps the notices are not as clear as they could be. And you've also seen the announcement that we are simplifying this annual certification process by standardizing the date. So it's going to be the same for everyone. The way it has been working is that the timing of that certification is triggered off of the grant recipient's separation date. So, for example, if you graduated from your Teach Grant eligible program in December, you're a December graduate, then they're going to send out that first notice that it's time for you to either certify teaching or your intent around December. And if you've actually started teaching, you're going to get that in the middle of the school year, when you obviously cannot certify that you've completed a full year of teaching because you're in the middle of the school year. If you graduated in the spring, then it coincides a little better with the traditional academic year, but then you have people who graduate in August, and it goes out then. So they're going out at all different times. So what we're doing is standardizing it so that everybody will get this initial notice around the beginning of October, and they'll have 30 days to submit what's required. If we don't get it by the end of that 30-day period, they get a second notice with another 30 days. If they don't respond to that, they get a third and final notice that sets the absolute final deadline as December 31st. And as we transition to this new system, there aren't going to be any more conversions for missing. So if your certification date was originally would have been like I don't know, May of this year, that's going to be suspended because we're transitioning to this new date. So we think that's going to make a big difference. So,
Thanks for explaining.
okay.
Thank
Just
you.
want to clarify one, because I didn't realize that the separation date was the trigger in terms of timing. So is it correct that there were Teach Grant recipients that were being told that they had to certify when they wouldn't actually qualify for that service, even though they were in the
Well,
process
you
of
did
doing it?
mention that when ACS was a servicer, we are aware, and that's out there as public information, that there were cases, and we have been attempting to address those, where there were grants being converted in some cases while people were still in school or less than a year after they got out of school. So we are aware, but I don't, as far as I know, that has not been happening for some time now, at least not with Fedloan.
But has the department done an investigation of Fedloan's current servicing from 2014 to the present?
Yeah, we're aware of what they're doing, and I'm not aware of the things that we know were happening with ACS happening with Fedloan recently. If you're talking about people having their grants converted like while they're still in school, as far as I know, that has not happened. If I could go back to the grant recipient you mentioned who withdrew, under the current regulations, if you withdraw from the program without completing, you leave school without completing the program, within 1 year of ceasing enrollment prior to completing the program, you have to certify either that you've started qualifying teaching, you've re-enrolled in a Teach Grant eligible program, or you've qualified for suspension. If you don't do that, within 1 year, your grants get converted to loans right then. So that may be what happened with that person.
But if she was in a qualifying teaching position, it should not
If
have
she
happened.
was,
Yeah.
then it should not have happened if she submitted the certification by the
Right,
deadline.
which she did.
Which she did, and it
Yes.
got converted. Well, did appeal that, and did it get
She has
fixed?
tried, and it has not gotten fixed. And when she called her servicer, she also was not directed back to the department or made aware that she could also appeal
Well,
that process through
then
the
she may be
ombudsman.
covered as part of this outreach effort that we also announced, to reach out to people who were either satisfied the service obligation or are in the process of doing it, but had their grants converted to loans. And we have put out information on that, and there'll be more coming out. So she may be one of in that population.
And when you say I have seen notifications that the department will be doing something, but it
Yes.
hasn't specified what the department will be doing. What?
We'll be sending an email out to the people that we've identified, notifying them of this opportunity, that they can say, yes, in some cases, I satisfied all 4 years, or I haven't satisfied all 4 years, but I intend to, and I'm able to do it within the 8-year period. If you want us to reconsider the conversion of your grants to loans, contact us. That's what it's going to say.
But why wouldn't it be automatic?
Because we don't know in some cases, each case is different, whether they actually met the requirements. We still need the verification of it. In some cases, we don't have that, so we can't just automatically do it. We may need to still collect documentation from it. Well, let me give you an example. So say someone did 2 years of teaching and got credit for it. Then after their third year, in the third year they missed the deadline, or they didn't get it in by the deadline, but they continued to teach, and then they continued to teach another year, but they had their grants converted to loans. We don't have any documentation of those third and fourth years, so we're still going to need to collect that. And once we get that, then we would reverse the conversion to loans. Do you see what I'm saying? We can't just do it automatically. The only time we could do it automatically would be if somebody had already completed all 4 years and had submitted the certification of the fourth year, but it was maybe turned in past the deadline, or there was some minor item on it that was missing and it didn't get corrected by the deadline, and they had their grants converted to loans. In that case, we would already have the documentation and we could just automatically do it. We can't do it automatically for everybody.
And on one hand, while I understand that, so I am an attorney, and the reason that the OMB process came about is a law called the Paperwork Reduction Act, which is intended to protect the public from misleading information, from an overly burdensome collection of information. And within that act, if a form doesn't have an OMB number, the public in the statute is entitled I want to say it's the public protection. Yeah, it is public protection. Public protection that you could raise the lack of an OMB review as a defense against incurring a penalty for not submitting that information. But none of those three forms were approved by the OMB.
Brian, I think, we've addressed this issue before, but you're correct. If it doesn't have the OMB number, you're not required to complete that form. But there's still a regulatory requirement for you to certify information by a certain date. So you've got to do it one way or the other. So would you agree? Is that basically the answer? Do you have a better way to explain it?
Without getting into a long legal discussion, the borrower still needs to prove their eligibility for the benefit. They don't have to complete the form if there doesn't have an OMB number. We can't hold it against them if they don't complete the form. However, they still have to submit the information. We don't have the information on file. Once we get the information, we can determine whether they meet the eligibility requirements. Arguably, they could submit it in some other form that we would prefer not, just because we're used to dealing with a particular form, but if they did, we would have to consider it. And we can't hold it against them if they do that. But it doesn't automatically give them the benefit just because the form that was being requested wasn't cleared by OMB.
And I can hear how you're defining receiving the benefit one way. I would say that if their grant is converted, that is a penalty, that under the law it says, notwithstanding any other provision of law, no person shall be subject to any penalty for failing to comply with the collection of information that is subject to this subchapter if, and then I can print off the statute. But I wanted to raise that issue for the subcommittee because it is pertinent to me as an attorney and also to the clients I serve, because it also doesn't feel fair to them.
No, and I'm not disputing that point. We are taking a number of actions. I think the department has conceded that there are a number of problems with how Teach has been administered so far. We are taking a number of actions to try to correct it. Those notices that John mentioned are expected to go out. They're on schedule to go out around January 31st, within the next couple of weeks. And the department is committing the resources to make sure that those are looked at and hopefully fully addressed. Now, we're not going to say that everybody who was in that situation is going to get their loans reconverted to grants because they, one, may not provide us the information, or two, they may not qualify. But we are committing the resources to address what we admit is a significant issue.
Is every student who experienced a conversion going to be sent the email, if you have an email?
I don't know that it's everybody that we're looking at. People, obviously, people who self-converted are not going to get one. There are going to be some people had their grants converted to loans and then later got those loans discharged for a reason like due to total and permanent disability. We're not going to be sending out to those. But other than that, it will be going out to a very large population of people who had their grants converted to loans. Yeah, I think in some, because I think it'll go, I believe I'm correct here, it's going to be going out to people who had their grants converted to loans basically because they either missed a certification deadline, which is the main problem that we're seeing here, is that people had their grants converted to loans because they did not get something in by this annual deadline, despite getting the 3 reminders.
And can this information that you're sending be somewhere where if we are talking with a student who feels that they fall into that category where their loan was converted, that we can get to them that same type of information? So
yes, at the end of the month we'll be posting some more information on studentaid.gov that's going to explain it in more detail. We did put out an electronic announcement in December to kind of briefly explain what we're going to be doing.
One thing I would like to recommend as you all push this out is, and I know you did, it was hard in December because it's hard to get anybody's attention, but we did see it at AECTE, and I'd like to encourage you to consider working with organizations like mine and others to help spread the word out, because I think the more that the public and those in the program know that you all are taking this step, I think it's super important, and also making sure that students do get that touch point along the way. I know you put the notices out, we saw it and blogged on it to share with our membership, but we know it's not getting probably out there enough yet. So we'd like to, work with you all to find a way to make this happen on a great level for these students.
We can probably provide copies of those to the members of this subcommittee. And then to the extent you can help provide it to your members or to other people you have contact with, we'd appreciate it. We do want the information out there. So we can use this process to do that.
I also have to say, though, it is concerning to me that after Teach Grant recipients have been told time and time again there is no appeal process, you cannot convert your now loan if it's converted, that the department appears unwilling to consider an automatic reconversion process. There are automatic actions that are already in existence in the education regulations, such as when a school closes, 3 years after, if the student hasn't asked for an automatic school discharge of their federal debt, the department now has to automatically discharge that debt. I think a similar process should be used here. I understand your position that that you would have to ensure that the service requirements were complied with, but I also see that the department did wrong in its administration of this program.
I don't want to suggest that the department will not, that's too many negatives here. The department, there may be situations in which the department decides that it can do an automatic. We're not doing it across the board based on improper servicing, but there may be situations in which it is clear from the documentation that we already have that the borrower met the requirements. In those situations, we're not going to request more information. If we already have the record, either us or the servicer, we will. The intention is to do the conversion in those instances.
That is correct, and in fact, I've got to turn on. What we're going to do is for those people who submitted documentation that they had completed all 4 years of the service obligation, and we have everything showing, but they got their grants converted because they submitted the last one late. We are going to exclude them from this campaign and just deal with them separately because we essentially can just automatically reverse the conversions. But as Brian said, we can't do that for everybody because we still need to verify that we're giving them the opportunity. All they have to do is contact the servicer, and then we will look into their situation. But we may have to require them to provide us with the documentation showing that they met the service obligation, or that if they've met some of it, we will, but they had their grants converted simply because they missed a deadline, we can change their loans back to grants, but then they'll be informed you're still responsible now for satisfying the remaining portion of your service obligation. So we are going to do it automatically for those people who already satisfied the 4 years but had their grants converted because they missed a deadline, if we can.
And I would hope that our committee would find a more inclusive solution, because while that sounds okay in theory, there are teachers who have had to leave these qualifying jobs, that had to work with a union, that had to do a number of different things to even get in the position in the first place. When they had the grant convert, now having to deal with those loan payments may have made the salary in these schools, which are traditionally lower paying, untenable for them. And so I think to expect them to have then complied with the service requirement after their grant was converted, which put them under more duress, is not right. So I would just hope that we as a committee would consider a more inclusive solution for those 78,000 teachers.
I'm sorry.
Well, that's very compelling, and I love all that data, and I'm going to be the first one on your soapbox when you go after the feds. But for today, I think what our responsibility would be is to remember all this information that Kira has brought to us and put something now in place that would protect them. There's not a lot we can do as negotiated rulemaking to fix the past. But I'm on that soapbox with you. But today, I just want to make sure that everything we review is tightening that up.
But legally, it is within our purview to consider what remedy the secretary should adopt to address those past grievances as well. So I agree with you. Let's move on and discuss. I'm obviously raring to go about the dispute process, but I just want to make sure that we had that.
First of all, I do want to thank you for the lively discussion. I wanted to address though something that you had mentioned regarding, is it Kira? Kira. Okay, that Kira had mentioned regarding the closed school discharge, just to say there's a little bit of a finer point that I wanted to put on that. With the closed school discharge being automatic after the 3 years, we have other information that we can go to. So we are looking up those students' records within NSLDS to say, do they have enrollment somewhere else at another institution? Because if they do, then they don't qualify for a closed school discharge. If they don't, then we can grant the closed school discharge. So that piece that is within there is not just to say that your school closed and you've been out at least 3 years, but it's also that you've not enrolled somewhere else to continue that education. So we have the information available to us in a database that we can refer to. There's no need to then go out to the student for additional information, whereas here we feel like we need additional information to make the determination. The other piece I wanted to add on a somewhat unrelated topic was when you're talking about us getting information out to students, we typically will do that on things like studentaid.gov. We can also ask the press secretary to put something out on the department's Twitter feed and to do press releases and to get information out that way. So if the committee has recommendations for other places, I don't want to just say, you know, Twitter is it. I mean, I'm my age, and so I know how to use these things, but, you know, there may be something that's newer that it's like, oh, well, everybody's using this now, and that's some other platform that we might be able to reach students. So if you think of those kinds of things, feel free to include those. They're not something that you would necessarily put into the regulation, but, you know, we don't want to be that prescriptive. We want to allow that to be much more general. But if you have those kinds of operational suggestions and there are things that you think would be useful, feel free to let us know. We can pass those things along, especially within the context of rulemaking. They want to publicize the kinds of things that we're doing here and that, you know, you're spending your time coming up with ideas. Many of you are on campuses, so you have that kind of boots on the ground feeling that we may be a little more removed from. So we'd like your feedback on those kinds of things as well. And just thank you again.
I appreciate the department's attrition in this. The one thing that is a little unclear for me, and this goes to us making sure that the right information is in the policy going forward, was remedies for those that have gotten information in error, did something else in corrective action outside of fulfilling their hours. Say they went into administration or worked for the district office or did something else in order to pay off, maybe even left the school district altogether because now they have a loan that they have to pay off that their job is not going to necessarily satisfy. And so I'm just a little unclear as to how we can move forward and put something in here if an error does occur and someone does something outside of the remedies we have typically considered, how they can still become whole at the end of this process or get back into the appropriate graces in order to complete their service. And that's for anybody with from the department.
To the extent you want to get into that, I would suggest you focus on the second part of your proposal, where you look at what can we do to provide the teacher with more time, or the idea that we would provide some form of, I don't know what, compensation to the student, it takes it outside the bounds of this program and puts us into almost a damages type approach, which is not going to work. So the appropriate way to do it, it seems to me, and I don't know how the department's policymakers would look at this, would be to say, in those types of situations, if the teacher was given incorrect information, how would the department would provide more additional time or provide a suspension for the period of time that the teacher was outside the teaching window, outside the teaching profession or something like that. That's just an idea as to how it could be done. Again, I have no idea what the department's policy thinkers would how they would consider it.
I appreciate that.
But along your same thought of how to make folks whole who have had their grants convert, will the department be refunding the loan payments that were made when the grant was wrongly converted?
And interest?
And interest, yeah.
Yeah, it's going to depend on individual circumstances. I mean, most of these people, I think it's probably the case that the majority of Teach Grant recipients also got regular direct loans. I would think that most of them. So it really is going to depend on individual circumstances. We've had other cases where that are going to require special attention, where people had their Teach Grants converted to loans and then later had those loans forgiven under the Teacher Loan Forgiveness Program. So you have to look at those differently too, but they will be made whole, is the short answer. But there's no one answer that's going to apply to everyone, because it's going to depend on an individual's circumstances, what other loans they had, whether they made payments on the loans. But the intent is to, I'll put it this way, make them whole if they qualify for the reconversion.
And so then along the same line, so there are students that my office sees all the time who have then gone into default and have now suffered adverse credit consequences. I mean, this can be incredibly destructive to a teacher's life when they have a grant convert unexpectedly. Would you also remove those individuals from default status?
That is something, you know, where I don't know how many of them there are, but they would have their grants converted to, or their loans changed back to grants too. And so if those were the only, the question comes up, what if they may have had other loans that also went into default? And that's a little more complicated there. I mean, you're making is your argument that they probably wouldn't have gone into default on all the loans if not for the conversion? I think we'll have to look at these. I know you're looking for like one answer that applies to everybody, but it's complicated, and we're going to have to deal with these on an individual basis. But as Brian has said, our intent is we're really putting a lot of effort into this, and our intent is to make these people whole. If they really were satisfying the service obligation but had their grants converted just because they missed a paperwork deadline or there was a signature missing and they didn't get in on time, our intent is to provide relief to these people and do whatever is necessary to make everything right.
And I definitely appreciate that. My goal is not to find one answer, just to get more clarity around what the department is thinking, because as was discovered during the public citizen FOIA litigation, the department has known about these wrongful conversions for a while, and FedLoan asked to be able to reconvert the loans, and the department did not.
Well, we actually had an earlier effort that I don't think was publicized to deal with the ACS issues, where we reached out. And my understanding is that we reached out to those people, and in many cases we never heard back from them, which may simply be because these are people that really we're not teaching, and they weren't satisfying the service obligation. But we did have an earlier effort to reach out to those people. But I believe we're going to reach out to them again as part of this outreach effort. So people are going to have plenty of opportunities to contact us and say, I want you to reconsider the conversion of my grants to loans. And there are going to be, I mean, the majority of people are not in default, but there are going to be individual circumstances that we're going to have to figure out the best way to deal with them. And the people who are in default are probably in that category. Just like with people who consolidated some of these loans. They got the loans discharged for some other reason. They're going to be a little more complicated to handle.
Okay, with that, let's move on.
Great, let's.
I do just want to say that was a really important conversation. So
Yes.
thank you to everyone who participated in it. Really important.
Yes, sooner
And I
or later
just-
we knew it was coming, right?
I just wanted to add in that I think it's, despite the time frame and everything and knowing all of these challenges, the department has seen to take the action, and I think that's important. And, you know, maybe some feel it's a little too late, but it sounds like you're taking into account the multiple circumstances that you're going to come across, and that this is not going to be easy by any measure, just as you're starting to describe it. And so kudos, and I think we're all going to be watching as you move through the whole process. So thank you.
And one other just very quick comment. We didn't specifically address, I think you brought up the idea of, the consequences of default and things like that. We didn't specifically mention things like credit retraction. So, retracting information from the person's credit bureau reports to say that they were in default. Those are things that we're already doing with other discharges. So we already have process in place for those kinds of actions. And I think that, that flows right into this kind of activity that we're doing as well. So I didn't want you to think that we didn't hear that, or that we had forgotten, or that there was no plan in place. So that too.
Thank you again for the conversation. Sort of to bring us back to where we stopped yesterday. We were about to start into 686.41, which is periods of suspension. And here, you may recall yesterday that we discussed that we had added residing or being employed in a federally declared major disaster area as an additional basis for the grant recipient to request a temporary suspension of the period for completing the service obligation. So here we point this out again, and then additionally, we provide for a separate 3-year limit for the suspension and allow for a representative to submit a request for the disaster suspension on the grant recipient's behalf. So you can see clearly here in 4 and then again in Romanet 3, these pieces. Then we have included those by cross-reference to 4 in B and C. So I'll give everybody a moment just to look at that and see if there's any discussion on that.
I have 2 thoughts. One is I would hope that we could include if a student has submitted a dispute regarding a qualifying service year or, I mean, who knows, a wrongful grant conversion, that those issues would still qualify for a clock suspension. And I'm also curious about Mr. Walters' thoughts about whether or not this suspension provision is inclusive enough, considering the students that you work with on a regular basis.
There was, I agree with that. I think that needs to come down probably a little further than the one that I'm about to suggest, which is when you change, and it might be in here and I'm just not seeing it or reading it, but I've read it a couple of times, and it's the certification is by state. So if one was to go to another state and start their certification or have to be recertified in the area in which they're already certified in one state, the way that the language reads, it's clear that they could get another certification for another area, like where we talked about getting a master's degree in another area for certification in one of the areas, the fields that are needed. But it's not clear if one can get recertified in another state and have that extension, because when they first go to another state, let's say I move from Virginia to Maryland or to New York, that I'm not immediately certified to teach in that area. Therefore, I don't necessarily meet the qualifications to teach math, or science in that particular state. And therefore, I might end up not being able to teach in the area in which I am certified. So if I could enroll in the certification process for that state and that extend my my service time, then I think that would be beneficial to many of our candidates that are at least looking at taking out a teach long.
So are you suggesting enrolling in another Teach Grant eligible program? Is that what we're talking about?
Yes, and the way that it's stated in, I think, the beginning of the suspension, the periods of suspension, doesn't necessarily address it from the standpoint of if I'm going into another state.
If you look at A1I, as I read it, and it's not something that they changed, but as I read it, that does seem to sort of cover it. So if you can elaborate on where you feel it doesn't quite cover that, that would be helpful.
The way I read A1I or A1, A1I.
So the next sort of paragraph down. Enrollment in a program of study
would be eligible for a Teach Grant, but has been determined by the state.
Or in a program of study that's been determined by the state to satisfy the requirements. So I think that this would allow for, if a teacher does move and reciprocity doesn't exist between the two states in which the person resides and the one they're moving, that if they do need to go take a course, as long as it's still a Teach Grant eligible, then it's
But
I think we were trying to make the distinction, which is why I asked the question is, if you're going back into let's say you have already gotten your bachelor's, now you're going in for your master's in a Teach Grant eligible program, then yes, you have the option of getting the suspension. But I think that's not really what you're asking, and that's why we're trying to get it clarified a little bit more.
I think I understand, so correct me where I'm wrong. If you move from one state to the next, you get licensed in your initial state where you're residing, you move to another state. Some states have what they call reciprocity, where they recognize each other's teacher certification and allow you to just, then it's like, okay, I'm there. But also there are states that don't have reciprocity, and then you get tested in some area. It may be your area of expertise. If you're a physics teacher in high school, you take a physics test or you take their test and you can be certified. But you could move and you get what they call a provisional certification to get in the classroom, and you still need to go back and take a class to then become certified. Is that what you're
yes and no.
Okay.
That, as well as sometimes you have to just pass a test, right?
Yeah.
Going back to our original conversation, if we look at this and just if they enroll in a program or a area of study, that I see does satisfy that. But if you are still, you have to pass a test. You're not enrolled, but you have to pass now the New York certification exam for that particular area because you previously had passed the Praxis, another certification test, covering some of the same information, but not necessarily used in New York. Is there an extension or an suspension while you are working towards that license or towards that certification? And I'm not for sure this is clear that can happen.
I think that actually may be more of a question around, because you're probably provisionally in the classroom, and as long as you're provisionally in the classroom while you're studying, you should still be able to be certified in this particular case. But as we're talking about it, and this is an issue that's been sort of in my mind, in that through the Elementary and Secondary Education Act reauthorization, we got rid of the words highly qualified, except that the Congress left it here. And that creates a challenge because the highly qualified definition is not required for the state. The state does not have to adopt the definition that's in these regulations. In fact, it's up to the state to determine what is an effective teacher. There are states, by the way, that now no longer require a teacher to have a bachelor's degree. So it becomes far more, we're going to see other issues as this highly qualified definition that's in the regulations, because I hear you on, and I think as long as they're provisionally in, they would be meeting the service requirement, and so that document would be okay, but somewhere along the way, the highly qualified definition is going to start tripping things up in a very, very ugly way, which in fact, it was such a subtle little spot that I'm not sure the higher education and all of us caught that we had to have, that this was not dealt with. There was an expectation that there was an error in HEA, that the words highly qualified were still there. So the department has done and picked up a definition that I think is not necessarily challenging from the perspective of that's a definition that's been in law before, but as we move forward, that definition is going to be difficult. For example, in that particular state where you don't need to have a bachelor's degree anymore, there could be students who are going through, now I know this is an extreme case where somebody moves, there could be teachers getting tripped up on whether or not they meet this highly qualified definition for this moving forward. I don't know if I'm being overly concerned or.
As a particular example, so let's say that in another jurisdiction you had completed a program or had gotten certification and then moved to New York. There's nothing that precludes you from meeting the New York requirements for certification while still residing in that other jurisdiction. So I would argue against actually adding suspension because for those instances where you don't need to enroll, that you just need to do a test, because you could do that while still in the other jurisdiction.
Do you know if that's true in other states as well, though, or is that unique to New York? I'm really glad you raised the highly qualified definition, because walking out of our conversation yesterday, I did get calls from some of my K-12 policy colleagues that work with teachers, and they were also flagging that will be confusing for teachers on the ground. I also wonder if folks, when they're provisionally certified, still qualify as highly qualified teachers under the regulations.
That is one of the challenges there. I'd have to go back and read through it specifically.
Well, I was just actually going to flag that. And maybe, and this isn't necessarily always our area of expertise, but on page 3, and highly qualified, on the bottom of the page, Romanet 2, the teacher has not had certification or licensure requirements waived on an emergency, temporary, or provisional basis. I don't know if there's exceptions that are later on here, but I did want to flag that.
Yeah, I think that's the major point there is moving forward. Do we, given this very situation that we're talking about, where somebody does move, maybe they don't necessarily know that they're going to have time to study to prep for that, and they just have to make quick family decisions. Parents need you to move home or whatever. That maybe we look at that and see how we deal with it. It was something that I had flagged for us to come back to. So,
and for me, it's about us just making it clear, because you see the debate that we're having here. I think candidates are right now making decisions on the Teach Grant, as well as some have making decisions once a school closes or a situation changes for them in their school district. They're not for sure that everything that they can move or that they can continue their service to meet the obligations if we're not clear in this document. So I appreciate, and you're absolutely right. That's where I guess I'm really getting the hang up is what we had talked about earlier as far as the highly qualified. I could see in some states, like in Virginia, a provisional teacher, even if they're teaching in that area, they would not be necessarily highly qualified until they have passed the certification or licensure requirements for that particular school district, and they cannot do that for 3 years because they have to show service in that school for 3 years before the state then grants them. And there are other states that are very similar in that regard.
So based on this conversation, is there any language that you would recommend for this? Or that as the group would recommend? Let's take it even broader.
I think we'd like to maybe have an opportunity to look at that highly qualified definition
Yes.
before we start offering language.
For the suspension, you mean, or just in general?
For the question at hand around what we're all trying to get at, it really revolves back to the highly qualified.
Okay. So do we want to put under the highly qualified a note to go back to this and connect it back to the suspension?
Debbie, is it,
Would that be-
does it connect to the highly qualified or to licensure? I was a little unclear. That was.
Debbie, so.
I'm sorry, Deborah. Deborah. I'm not for sure. And the way that I was, I reviewed it before, I was thinking licensure was the connection piece here. But as you talked about highly qualified, I know that my understanding of licensure was connected to the highly qualified piece. So I'm not for sure.
Yeah, that's what I'm saying is let's go back to the highly qualified definition after we get through all of the regs and really think about this a little bit more, because how we do this is going to have a big impact. So I didn't want to try to go back to highly qualified definition right now. And your issue was around that provisional, temporary, or emergency licensing. And I think you bring up a good point that some states will give you that, and it's 3 years, and there's nothing you can do, and then you opt in. And I think that's something else we need to think about moving forward, because it's different in every state. And as their shortages pop up and needs pop up, they can adjust. They're pretty nimble at the state legislature on this kind of thing. So.
No. So it's not needed to take a test. It's because, well, so actually needed to take a test, including like the wait time when you're waiting to find out whether or not you pass the test to make you certified in a state /
Well, it's really licensure requirements, right?
yeah, time needed to fulfill
Time.
licensure requirements
Yeah, would
outside
be-
of
would be the
period-
most
program of
encompassing.
study. Mhm.
I mean, that's there in the suspension. I feel like that's covered in the suspension.
The-
But looking back at the highly qualified is where.
You feel like
So I-
the program
so-
of study is covered, but if you're provisionally certified, it is not, right?
It's, if you're provisionally certified, you're not considered highly qualified,
Yes.
so you don't meet the requirements to
Yes.
receive the suspension because you're not fulfilling your teaching requirements. Is that correct? Am I saying
I
that
don't-
right?
Yeah.
Okay. Thank you.
Well, wait a second. So, but your clock would still be ticking regardless of whether or not you're highly qualified. You're whether or not you fall in or out in one state or another. If you can be highly qualified in one state, you could still, in theory, request a suspension on the basis that you moved. You are no longer highly qualified in that state and are working towards becoming highly qualified. It's just not here now.
I think your words "working toward" become the question there, because, sorry. I think your words "working toward" become the question there because if they don't have, it's a question of are you enrolling in a Teach Grant eligible program of study to get those, whatever you might need to become certified.
Or if it's not a program of study and it's just you have to teach provisionally in the state for 2 years without incurring any warning or whatnot.
If we adjust the highly qualified definition, wouldn't that then allow them
Yes.
to meet that? So that would be
Totally.
taken care of by looking at the definition.
I see what you're saying. I'm just saying it's not covered in the regulations as they've been currently written.
Any other comments on this piece?
In response to Willis's example, excuse me. Yes, in 2I, it says does not exceed a combined total of 3 years under both paragraphs. So as we are holding for review, we might also want to flag the time limit.
This is for 2I? Just 2I?
Yes.
On page.
So I think what you're saying is that it's not enough time.
Well, it may not be.
Okay,
I just think we
that's-
need to,
all right, yes,
that's a
got
very
it.
limiting language right
Yeah.
there, and I just think we may need to flag that to address as we learn more about the requirements to meet the highly qualified or strike the highly qualified. Whatever we decide to do there, we just might want to come back to that to revisit it.
Anyone? Yeah.
Who would they submit a suspension request to?
It goes to the teacher grant servicer. And I don't have any numbers, we could get them, I think, but my understanding is that there really aren't that many suspensions granted. I don't think, based on what I know, that all that many recipients request suspensions. I mean, we could get the numbers, but I don't think it's a real large number.
But they could also be converting before they would even be able to ask for a suspension. So I don't think that data point is.
Well, I mean, from my experience in two different states, Florida and Virginia, I've had a lot of conversations with candidates that have even thought about taking out a teach grant because they feel that it was too limiting in where they could teach, or and it wasn't. They wanted to serve that population of students and in those kinds of communities, but were concerned that they either would not be able to get the job in the particular area that they were in or could afford, and they were also concerned about the suspension of time between, or the extension of time between when they could get a job and the 8 years, especially considering some of the areas like in Florida, rural areas in Virginia that may or may not necessarily be hiring their particular area that was stated by the state as well as by the federal government.
I think it would be helpful to just have a sense of the number of suspensions that were requested and the suspensions that were approved. I mean, or if suspensions have been denied. Just curious.
Okay. We can request that.
Related to that, I think it'd be helpful to have some leading reasons as to why there was denials.
Yeah, thank you. I was also gonna say, to clarify, it's the servicer who is the one responsible for determining whether the suspension should be offered, or not offered, but granted. Thank you. Right word. Thank you.
Requirements for the suspensions, so that they would be approving them based on what's in the regulations. And the requirements are pretty spelled out pretty explicitly. They're pretty cut and dry. They're not areas where it's a matter of discretion. It's either you meet the requirement or you don't. So,
is it possible to also see the documents that the servicer has in front of them? Because you said it's pretty cut and dry. I think there's just, I may be speaking for too many people around the table, but there's an obvious, for many of us, there's a concern around how FedLoan is operating. And just want to, if they have everything that, they probably do have everything that they need. We're just curious about how they might be operating in this space. So,
like the requirements that they are following for the suspensions, yeah, we can get that.
Thank you.
Will the suspension decision be appealable to another entity within the education department?
I am not personally aware of any cases where people have appealed the denial of a suspension, but if they did, my assumption, as far as I know, it hasn't happened. If it's happened, I'm not aware of it. That would come to federal student aid for review. But as I said, I'm not. If it's happened, I'm not aware of it. So, but we can find out.
To that end as well, is there a form that the student has to fill out that also helps make it very clear if they're requesting a suspension? Because I think that's also helpful if the form is as clean cut as what the servicer also has, or if they're one and the same or something.
Yes, there is a form, and if they're requesting a suspension based on enrollment in a Teach Grant eligible program, they also have to get that certified by an official at the institution to verify their enrollment. If it's for a Family Medical Leave Act condition, it's simply a self-certification. We're not requiring people to provide a birth certificate for their child or things like that. And then for military suspension, then they do have to provide documentation of the military service. But yes, there is a form, and that's something else that we will be clearing as part of this rulemaking too, because as you see, we're proposing to add an additional suspension condition. So if that becomes, if that goes through, then we would obviously need to modify what we have out there now to include that.
Okay.
So,
Thank you.
I wonder what the committee thinks about adding potentially an additional subsection giving the secretary discretion to, in exceptional circumstances, to offer us a 3-year suspension to include these sort of unexpected circumstances or variances between states that we've already raised in our conversation.
So do you mean something like if you relocate to a state where it's mandated that you teach for a certain period before becoming, or I'm not sure what you...
I'm saying in other statutes, the secretary will reserve discretion for itself to offer the option to someone. So here it's pretty limited, right? It's FMLA, it's military. And so what I'm saying is that we would want to give the secretary the option to expand.
I see. So if I'm a Teach Grant recipient and I've got something crazy that's not on this list happening to me.
Exactly.
Yeah, I think that... Mm-hmm.
Can you propose some language that we can put in?
Absolutely.
So let's just ask this question. Are we now done with the periods of suspension? Yes, maybe. I know Willis is looking.
I guess let me go back to my original question and making sure that what the answer it will satisfy what I'm saying. Under I, when we talk about enrollment in a program, I understand there are a couple of or statements there, but the last or statement where it talks about licensure to teach in the state's elementary or secondary schools, would it be stronger if we said requirements for licensure to teach in a state's elementary or secondary schools? Because right now it just says you have to either be in a program of study or licensure to teach. And I'm not sure that would be clear for me as a student or a teacher, a prospective teacher, as it relates to if I were to change from it to another state, if that would include what I'm going through.
So what would you put in there?
I'm thinking if we added requirements for licensure to teach, requirements after the or statement, the last or statement on I. David.
Yeah. That or is just acknowledging that some states call it certification and some states call it licensure, right?
So it's already there under requirements for certification. For me, I'm unclear because right before that it's talking about the program of study that has been determined. And I'm saying that it might not necessarily be a program. Right.
Right. I mean, as written, it's all about being enrolled in a program, whether that program is to be eligible, blah, blah, or to meet requirements. But right, this is all about enrollment program. And what you're saying is you want to see language beyond that.
Correct. I think there are states that don't require you to necessarily enroll in a program, but are holding your license for other requirements.
Could we just have a different little Romanette there that instead of starting off with enrollment in program of study, we could say, I don't think participating is the word, but leading to in some type of a vocation or requirements for licensure in the states? Somebody's going to have to do better at that than me. But I think that's what you're getting to. It's separate from program of study. But they're in some type of a program, teaching, whatever, to get their license. That would be the 3 years in Virginia.
And let me be also very transparent. My thing is, if you are highly qualified in one particular state, that should be transferable. Currently, that is not the case in our nation. And so I am trying to make sure that we are capturing that for those that might be in limbo between state to state.
I can also check in with some of my teacher communities to have more of an idea of all of these circumstances, because they mean that may be true in Virginia, but there may be other states. I know when I was in Louisiana, I was alternatively certified, and it wasn't a formal education program under this definition. I didn't have to get a post-bac degree or a bachelor's degree. There was no college credit. It was just a program that you went through for alt-cert, which wouldn't be covered here. But there may be other states, especially those states that may now no longer require an undergrad degree, where the rules are just more lax. I don't have the states immediately available.
I don't know if we're going to actually be able to capture all of these things, because in all honesty, the state legislatures meet, and they're meeting right now, and they're changing requirements.
I was just going to say, these change constantly. So if we address it, it should be something like, or otherwise fulfilling the requirements within the state. Because as soon as we put a time frame or a specific test or program in there, then yeah.
Just a question, is there a formal process for that?
Meaning a formal process for the changing of licensure and certification?
Is there, we're going to have to document it. Is there something that we can point to say that the teacher is in this working towards meeting the certification requirements? Is it something that the teacher is doing on their own? I mean, I would think that they don't have to, there might not be a legal record that they're doing it. So I'm not sure.
I think that's kind of what Willis is trying to get at, is for those people who maybe aren't enrolled in a full-blown program, but maybe you have a single class. Minnesota says, you didn't quite score high enough on our English test, so you have to go, and the teacher then decides, I'm going to take a class to get better so that I pass the licensure and certification. And so I don't think there's something that, your question is, what could we point to say, to check the box that they're doing it, unless it was acceptable that the department looks at, just sort of like with FMLA, and I know that's a completely different legal nightmare, that yes, I'm doing that. It's hard to know if there's any one particular thing. And also, I think the deeper question is, For some states, they might just reject that person and say, you can't come in and teach. And I believe that's what happens in Minnesota, but other states are going to take that person and provisionally give them, it's either temporary, provisional, or emergency, which all land under different definitions in each state. So this is where licensure and certification gets to be a little crazy because every state is different. There is an entity that tries to track it and work on that, and it's called NASDAQ, and I can get you some information on that. But I am about to step out of my bounds of expertise here, so I don't want to step into it. I wonder if, to address the kind of question that we're looking at, if still the solution isn't to find some language under the highly qualified that solves this for individuals. But also, if maybe there is some sort of, if we do decide as a committee to try and come up with language where the secretary, through this regulation, and that's something I'm not even sure, I was just going back to the law to see if it was written that the secretary has kind of discretion. There are certain entities that would, outside of the department, who would not want the secretary to take on new, and that could fireball in and of itself. But maybe it's in that, in some other way, we come up with another path as we look at disputes or working with the ombudsman, there we go, to find a way forward for if there is this unique situation where they're not going to let that person in the classroom and they need to be in that state or something. I think we can find a way forward, but no, there's not anything that we can just say like, oh yes, I'm doing this, check.
And it's messy state to state, and so I don't think we're going to find a one size fits all, and that was what I was the reason why I was saying that we really have to make it very broad, this particular statement, and I didn't think that this particular statement that we had regarding enrollment into a program necessarily fit for everybody. But
I would argue I absolutely don't want I would argue I do not want the words vocational training at all. Sorry, you just were trying, and I appreciate that, but that's a very, yeah.
Just a point of clarification, I'm not from Virginia, but in looking at the Virginia website for the DOE, it looks very much the same as New York State for out-of-state. And so you can get issued a Virginia license if you completed a comparable program elsewhere through an accredited institution, if you already have certification in another jurisdiction, a national board certification, and then you also, if you already have the out-of-state certification plus at least 3 years teaching experience, then you don't need to ever do the professional teacher assessment requirements. So it seems actually quite similar, and you would meet the requirements that are already in place to be eligible. So in that and again, maybe everything's not on this document, but it doesn't say provisional certified. It says Virginia license or certification.
Right, but if you, let's say, did 1 year in New York or 2, and transferred, you would not. You would be hired as a permanent sub, even if you finish from a math program or a science program in another state. We started the year with about 1,300 classrooms that did not have a highly qualified teacher in them at the beginning of the year. And large in part, they were began the year with a substitute teacher of record for those classrooms, large in part because they didn't meet all of the requirements on that list at the beginning of the school year. And so what I'm looking for is just pretty much a broad statement that would allow for those individuals to not be hung up in the in not meeting the obligation for service if their real intent was to meet the obligation.
So I think for now we can leave this here as as a sort of a trigger point for later on when we get back to the conversation regarding highly qualified. And then since it's already 10:21, maybe we can take our break now and then return and start with discharge of the agreement to serve.
Well, I have a couple more things
okay,
on this
good.
one, but we can
All
do
right.
it when we return if you want to.
No, let's finish it off and be.
So under 2, Romanet 3B, a grant recipient or his representative in the case of the grant recipient who qualifies under paragraph A13 or 4 of this section must apply for a suspension in writing on a form approved by the secretary prior to being subject to any of the conditions therefore. I don't know if the words, just getting to being, striking the words or clearing up explanations, must apply for a suspension in writing, like, like in writing kind of seems a little limited in our technical electronic age. I don't know what the...
We always interpret writing to include electronics. So
On
it
the
can be in
form?
electronic form.
On a
and
form
that's
approved
a
by the
goal.
secretary prior to being subject.
Yeah, so it would be an electronic form.
I don't know, there's something about that that's just bothering me, because we're saying that they have to apply to their servicer, but it reads as if it's coming to the secretary. I don't know, it's just a little confusing, and in this whole theme of trying to simplify, that's just a little confusing.
I mean, we generally, our regs refer to the secretary, even if it's our contractor. Yeah. That's just the style of writing. We could choose not to use a servicer,
Well,
but
yeah, well,
the,
maybe-
the writing could be. I mean, it's possible the language needs to be improved. We're happy to take suggestions.
And that's all I'm getting at here, is just making it, just clarifying it a little bit more to get to meet the ends that we're trying to get.
Would you like to make some suggestions for that?
I knew you were going to ask.
So I have an idea, see if this meets what you're looking for, to maybe just delete in writing on and just say via a form approved by the secretary.
Or manner or something.
Because, I mean, the form is, if I understand correctly, it's an electronic form that you would say go to the servicer's website and apply. Is that the process? So I think, I just want to make sure
Yes,
before we change
and-
something.
But some of these suspensions require some kind of verification of like if you re-enrolled in a program or you're in the military. And right now, we don't really have a process for, say, the official at the institution where you're enrolled to electronically, so that may have to be done in paper. We're exploring options for allowing those certifications to be done electronically, and that would have implications beyond the Teach Grant program, because it comes up in connection with loans, too, for requesting a deferment where there's a requirement for some kind of third-party certification or documentation. But yes, it goes to the servicer, and also the agreement to serve and the communications that grant recipients receive tell them they submit the request to their servicer. They don't say to the secretary. As Brian said, that's just the language that we use in our regulations.
And to that end, I have a question. Because it says approved by the secretary, that means it has to move through OMB, correct?
Yes.
So we don't want to remove that I just want to,
Yes.
or from the perspective of my colleagues around the table, we don't want to remove that. So maybe it's just, if not that, we could massage it over the break to say something about that you must apply for the suspension. I think, though, I like having the form language in there myself, because then that allows for that OMB discretion. So to review
Or maybe it
and
could be
such.
something along the lines of just in an official manner approved by the secretary, and that's not the words, so don't type that, but something that just says it's got to be approved by the secretary the way you applied, but it's not limited to writing on this form. Because what I don't want to lead to is, I'm going to
see.
fill out this form, I'm not going to meet all the other requirements, but I did it on time, and now I'm going to challenge my suspension. Challenge my denial. That's what I'm, it's like, this is
That's where
very
you're
limiting.
going. Okay.
I think I'll start out by just quickly saying we do use that language in many, many places in regulation. So if we take it out here, it's not going to necessarily be consistent with what we do in a lot of other places. But what I hear you saying is more you want to take out the in writing, and then it's more that you want to say on a form approved by the secretary, that part would stay, but that you also want to emphasize that there may be additional documentation that they have to include as well. So I think I would probably suggest taking out the via and just leaving the word on so that it still does say on a form. And I realize that form could be an electronic form, and we generally wouldn't necessarily specify that anymore, but that you might want to add something in that sentence somewhere to including supplementary and required information or required documentation. So just maybe, especially if you're going to think about some of that over the break, I probably wouldn't start another sentence, Aaron, just because my concern would be that then that it gets too long, but after approved by the secretary, or I guess on a form after approved by the secretary,
And
right in through there somewhere, that where you're typing, it wouldn't say the form, but maybe including any additional required documentation. I'm not married to those terms. You guys work on that, but it was just what I was hearing was that you wanted to include that piece, and I wanted to flag it for you.
And if I'm not mistaken, there's some language much like what I'm trying to do surrounding verification. You know, where you have to submit the FAFSA and any supporting documentation. Like, it's not just you submit it and you're ready. So I think maybe the department already has the language that I'm looking for, and maybe we can find that over the break. But I think it's already there somehow to remain consistent that this form alone, written down, is not going to always be the end. Because if they do that the day before, you know, or the day after their loan is to be converted, they just need to know going in, and everyone needs to know in the regulations that this could be an extensive process.
Go ahead.
Would adding language to the effect of a suspension does not begin until the secretary approves the request, and just having it be very clear, nothing, so that way the presumption that I submitted a form, therefore I've got it, wouldn't apply.
So two things to that end, because I think maybe as this document moves through OMB, we could address something like that, being sure that it is very clear. It may already be, we'll see. But also, and I would have to go back because I sort of did a brain dump last night, but making sure that on the exit counseling, that is emphasized as well. That you're requesting the suspension must be approved. And along with your concern around the time frame of, oh, I clicked it and my loan's going to convert in 12 hours. No, your loan's probably going to convert because you didn't do enough time. So there may be a couple of places where we could start to attack that issue.
Just a point of clarification. So on the one right below it refers to the documentation. So it's already in regulation that's there.
It is. It is saying that there may be more, but it doesn't necessarily. I don't know. I guess I'm just reading this differently because I'm reading B as a standalone. Like this is what I'm going to do to apply for a suspension. I'm going to do this thing, and then if I qualify, C is saying that if I qualify there, I must provide documentation supporting the suspension. But that doesn't necessarily mean that I am not already in the stop clock zone at B. It's not like in addition to, you will also be, you know, I don't know, maybe I'm just not reading that right.
I hear what you're saying. Maybe, Aaron, if we took out the language in blue that I had suggested to add up above, because I couldn't see all the way down to C, and I was thinking it just asked for some, I know it asked for contact information and all that, but maybe D could be added to say something there about the idea of the recipient would be notified in writing of the outcome of the decision, or something to emphasize that, you know, it is effective once you receive whatever. I mean, I'm just thinking really quickly, but I think what you're looking for is kind of and here's the ending, here's the finality of it. You know, something to say that they're notified, and maybe we don't want to say in writing because it could be electronic, so
Just
would be notified. Take out in writing, Erin? Under new D, yeah.
Take out.
So just notified regarding the outcome of the decision.
And actually, I think that would be E because we're going to have you giving us D.
There you go. So maybe you could put, Erin, make that E and put a placeholder for D for later. But hopefully that's helpful.
Can we add a time limit though on the response? I mean, but if we have
I've
someone
tried that
who's in
before.
an indefinite, like period of uncertainty, that also doesn't help these folks.
The issue, though, becomes that we don't know how long it's going to take to get all of the pieces required. And generally speaking, for these types of processes, especially in regulation, the secretary does not regulate her own activity. That's just that is how our regulations tend to be.
Could I add something here that's maybe related to this, that if you apply for a suspension and the condition that qualified you for the suspension began in the past, as long as that will be applied retroactively. I just wanted to clarify that. So it's not as though the suspension won't, start until it's approved. If the condition that qualified you for the suspension, say you re-enrolled in a Teach Grant eligible program 6 months before, then that suspension is going to be applied retroactively once it's approved.
Maybe I can make a little bit clearer of my concern coming from the financial aid world. In the financial aid office, we're required verification. I'm not sure if everybody knows what that is, but it's the lifeblood of my industry. But so we have verification. And what I'm trying to get away from is because students will, in good faith, fill out the federal verification form, turn it in, and walk away. So they're thinking, no, I'm just saying, so they fill out this form, this suspension form. I've done it. I'm walking away. I may need verification on household. I may need tax returns. I may need last W-2s. And I'm asking, but they're like, I filled out what you told me to fill out. And I'm done. And I did it on time. And then inevitably comes May, and none of their aid has posted. They're like, I did it. I did it in August. Because in the finality of us asking for a form in just one singular place without any, and must complete the full process before we're going to even consider your suspension, is just bothersome to me.
But I wonder if your issue can be addressed on the form itself.
Yeah.
Meaning making sure that we get that verbiage placed on the actual form for the request.
And it may already be there because you said you would bring some, maybe this is something we need that form faster than you realize so that we know what the students are actually sort of looking at electronically so that we know the verbiage is there. Because I hear your concern that, I typed in my stuff and off it went. And since I didn't hear anything back in an instant, I got my suspension. And so I stopped worrying about things.
Because of the delay that Kira described earlier, they're assuming that they turned in their information and it's done, and then 7 years later they're like, what is this unconverted loan? And so much time has lapsed, and I just feel like we could just do a better job at putting that even in the reg, because if we don't have it in the regulation, something like what Anne Marie suggested, except that maybe instead of being notified, is that the suspension does not even go into consideration until all requested documentation has been received. Something like that, I think, is what I was reading about the verification. And again, we can get language during the break and come back, but I just want to be clear that it's not that I don't think we have it spelled out if we're looking really hard for it. I just want it to be very transparent and very clear that the clock does not stop just because you've done this. And I think just relying on the secretary to send notification leaves an open window, because we know it won't be immediate, but they're getting on with life, and I just don't want it to be a surprise in 5 years.
So
I
maybe we,
think
okay.
just one additional piece. So these forms are not available on the Teach Grant FSA website. And then when you go to the Fed Loan Servicing website, Teach Grant is not one of their main things that would drop down. So one of their main drop down menus. And so I would strongly ask the department to consider making sure that all of these forms for a suspension, a dispute, are available on the FSA website where the Teach Grant is explained, to make sure that even financial aid officers who are advising students, how would you get access to this form to be able to provide guidance if it's not publicly available?
I don't disagree with what you're saying in terms of content, but I go back to something I said yesterday. Certain things don't need to be in regulation. Is there a better place that this can happen? So if the form goes through another process, then that, in my mind, is the place to do it rather than regulation.
Yeah. And any form would go through a different process, so you would have that. Why don't we take our break now? We're past our time. And say reconvene at 11. Does that sound about right? Since it's okay. Just checking. So what do we have? The Fed loan?
I don't think that's the way.
Oh, because I'm blind. That's why I need these things. Can't see anything. Okay.
Do you have an extra?
Yes.
Thank you.
I'm sure.
Oh, it wouldn't count under FMLA or any of that if your spouse is deployed.
We're live? Okay.
If you were moving with your spouse, would there be other options for
Doesn't seem
you?
like it doesn't.
No.
But I know there's been a huge push on including military spouses.
I think as long as if they need to be a part of, I guess I was just thinking about a military spouse, not a military spouse who has a teacher. Because that's where it matters.
Right.
If both husband and wife, or wife and husband, or wife and wife, husband and husband, they both would for it to matter, right?
So let's get started. Only, I have a quick question. Do you think we should do for lunch an hour and 15 today, or was an hour sufficient? I just want to check that
I
because.
thought we all got back in time.
Okay.
So, yeah,
No,
I
I
think
just, it's Friday and it's quieter here, so I don't know if you guys are going out or whatever, so I just want to be sure.
Been an issue for that, and then we have issues getting back. And it could end up being,
Okay, so let's,
you know what I mean?
so we'll just plan on, because we have to stop at noon because of the requirement, and then so maybe we'll start up at 1:15. That way, if you're back early, that's fine, and if not, that's so fine. I just want to get the logistical thing out of the way in case we run over for any reason and just have some little play there. So before we move on, I think everybody received the handout. I don't know that we want to review this right now, but this is for you to take a look at. And then we can come back to it if there's anything we need to come back to in the afternoon. So this, just so you have it. And I'd like to move on to the discharge of the agreement to serve. And where we have our first,
Sophia,
oh, I'm sorry.
Sophia, before we go to that, we were just having an offline conversation about military spouses. And I'm not for sure that we've ever, it doesn't seem like we've made any provision for them. However, I do know many of the states are now trying to secure them and their as teachers. And I know some that are right now going through the process of becoming a teacher in our state, but they also sometimes have to travel with their spouses or would like to when emergencies arrive or new orders come in. Just throwing it out there, I'm not for sure of the numbers as it relates, but I also want us to at least consider the possibility of somehow including them in on the military suspension here.
So
Or another area.
Let me find where we were looking. So under Romanet 3, you would want to add the military spouses in some manner to this provision here. Is that correct?
I think that's the most appropriate place.
So if you have language, we can put that language in and see what everybody thinks about it. And if not, you can maybe think about it over lunch, and then we can add it after lunch. It doesn't really, whichever way is better for you. It is kind of a subset, in a way.
I mean, that could be something too, that if we craft language about other circumstances at the secretary's discretion, that could be something that could be considered under that as well.
I will say this is something that we've seen some legislation in Congress, particularly around military spouses for teacher loan forgiveness, and there's been legislation on that front. So I think it's something that folks are thinking about and is important.
That sound good?
Well, I like that, but I think we need to be clear. I think if we could include and or spouse, where we talk about member of service or member of reserve and other service.
But it wouldn't apply to all of these conditions then, so that's why I'm saying you need a carve out of some sort. That's the point I was trying to make, is if it being a subset. So that's why I said you might want to think about what is applicable, and then we could make propose a carve out here.
Yeah, that makes sense.
Okay, we can do that during the lunch break.
What do you mean when you say that not all of the conditions are applicable?
In other words, that the actual spouse may not be actually doing some of these things. So, which of these are actually going to impact the spouse in whatever capacity they're impacted? Am I making sense? Mm-hmm. No.
I'm still a little bit confused. Are you talking about when military service would implicate military spouse's ability to teach?
Yes, that's what the conversation is about. So the idea would be, for instance, the military member gets sent overseas. There's the most obvious example. What then? Mm-hmm. So, but not every one of these conditions under Romanet 3 would result in something like that. If that makes sense.
And there may be additional circumstances, like
that's why I'm saying
having a new station and.
It's a carve out to this. It's not all of this. Mm-hmm. That's the only point.
Stephen, do you have the language from the other grant that if we could tie in some of that language, that might be helpful?
Yeah, maybe we come back. I have the bill here where they were looking at teacher loan forgiveness for military spouses, and maybe we can just take a look at it at some point and leave a spot here and pick out what wording works best, if that works.
Yes, absolutely. Yeah. So there was the discretionary language, and then I'd also like to add language relating to a suspension due to a dispute or request for reconsideration is how it's termed later.
Is this where we actually want to have that? Because then they might think that by requesting the suspension, they've requested a dispute. And maybe it's something where if a dispute is requested, then if you kick off that process, then a suspension is placed on your...
Is automatically, yeah.
Possibly, or figure out some right way to do it. But I think, again, to Debbie's comment earlier, they may think, oh, I've requested it, therefore I'm done. And chances are that this would not be the case. So I would recommend we move that into more of the dispute process.
Okay, and not have it cross-listed in this subsection?
Yeah, because this is what a form would be generated for the suspension, which we have. So it would, confuse them.
I see what you're saying. Okay. As long as it gets included somewhere, I'm a happy lady.
Okay.
Could you scroll back to that language that was up? I just haven't read it. Okay, thanks.
Any comments on the language for now?
I'm just wondering if this is where we could have an inclusive but not exhaustive list and maybe cover the military spouse situation under D.
You mean saying something like including conditions related
to? Yeah. Right, but not limited to, right.
I'm not sure if we need, I am on. I'm not sure if we need to do that in regulatory language, because then some things could inadvertently not necessarily make it, but we could say, instead of listing off all the extenuating circumstances, because also a student may not understand that. They may not realize that their circumstances could be extenuating, but to the spouse situation, we could say exceptional circumstances, comma, like including military spousal something. I mean, obviously I don't have that language at the tip of my tongue. Or what were some of the circumstances you were thinking of listing?
I didn't have any on my mind because
Well,
this was originally.
So I don't think we would want to list them out because I think it could change from year to year depending on how things are changing on the state level as well. So there may be things that wouldn't necessarily create a problem now that will come up in the future, and I want that to be covered. With regards to military spouses, I think that's such an exceptional category of people. I think we do want to explicitly enumerate it outside of the exceptional circumstances case, in part to prevent confusion that folks don't think that the only extenuating circumstance is being a military spouse. And also because, to Sophia's point, I think there are specific things we would want to include so that military spouses would know that they could ask for a suspension.
Okay.
So I appreciate the reason for putting this in, but we're creating a new process without any guidelines as to what that process should be, and we're creating significant, so it's no longer sort of cut and dry as it is currently. And so as long as we're understanding that operationally we could be significantly increasing the workload for the servicer, and ultimately if there are appeals, then for the department. So as long as that's what's understood, and I'm not actually there yet that I agree that this should be there without any boundaries as to what this is. I'm just, from an operational perspective, I'm a bit concerned about this one.
It's very broad.
Yeah, and to that regard, other regulations have been, the CRA, Congressional Review Act, rescinded because of their broad, that they're stepping out past what's in the law and what is there to offer. So I hear you with that concern because it is pretty broad and people could find themselves relatively challenged as well at what the secretary decides to let go and not go and that discretion. So I understand the concerns you're raising, plus the process side of things. I think it opens up a can of worms that could lead some, as we're moving forward in this process even, that this is a whole new regulatory situation that either the department or others on the full committee may not support.
And just sort of to elaborate just a tiny little bit on that, we do always have to remember on the bottom line when we finally do our passes and get happy with everything, that cost is going to matter because there's this problem of cost. It's just how it is. So we just want to keep that in the back of our heads that, it's nice to have a wish list, but at some point we have to be looking at it more mindfully in terms of what's possible cost-wise.
I mean, I will say under the statute, the secretary does have discretion to determine when a suspension should or should not be granted. So to that concern, it is within the bounds of the statute. But I do hear what you're saying in terms of operational costs. I do hear what you're saying in terms of expense. I am just concerned that that the way it is currently drafted is too limited to capture people that may have a legitimate reason for a suspension. So on thinking about the teach recipients themselves, I am inclined to say we should create this new process if it helps more people fulfill the spirit of the Teach Grant program.
Well, and if we look further down and how under discharge of agreement to serve, if we use a similar language, rolling it under the Secretary of Education, what is it, 2? Under exceptional circumstances and the case-by-case basis, the Secretary, in this case, discharges obligation. If we had similar language, I think it at least gives the Secretary, it gives the opinion that the Secretary is able to do those things that are reasonable to assist those that are outside these particular parameters.
I think, too, only is a modifier on death. And so it's only exceptional circumstances pursuant to death, not
That's
generally.
my point, though, that in this particular, if we use the language there for earlier, for suspension, or a similar language for suspension, as opposed to having to wait for death. That it might benefit both everyone inclined, but also give a greater understanding of what the intent is here as it relates to suspension of the services. And I say the intent, it looks like we are trying to be clear, but we also understand that there might be some additional parameters we have not necessarily included.
So one of the things I want to bring up is in the law, it states that the secretary shall establish by regulation categories of extenuating circumstances under which a recipient of a grant under this subpart who is unable to fulfill all or part of the recipient service obligation may be excused from fulfilling that portion of the service obligation. But it's all, those categories are by regulation. So if we leave this open, then the department could possibly argue that they have to reopen negotiated rulemaking for any of these other extenuating circumstances and then start listing them off.
What is the department? Are there thoughts from the department on that?
Yeah.
On reopening.
On sort of, is that how you all would interpret it?
Well, we are adding right now the disaster stuff. Mm-hmm. And we are in negotiated rulemaking. So to that point, I mean, that would be the process to do it. But would we reopen it again? I'm not following.
Well, I guess I'm just wondering if you all
I don't think
at the department feel like this language is so broad that it is essentially irrelevant, which is sort of what we.
And to further that, would you currently grant a suspension for natural disaster without making this change? You wouldn't.
Right now, for this, we don't have the regulatory authority.
Right.
Okay.
So, I mean, it does matter what we put in a lot. But again, this is very broad. How would you define exceptional, for instance? Just as an example. Mm-hmm. That's kind of hard to.
So I would say the same way that we are using it under discharge and agreement to serve.
But the discharge language relates to evidence. We can conclude that other evidence, we're not granting somebody a benefit or a suspension here with, it would be helpful. I'm not sure that this broad language would survive department review, because people would say, what do you mean here? If we could get what we've done in at least one other case is to say exceptional circumstances such as, and then given at least a descriptive list. And that may be a way to try to address. It would allow us to expand the list, but it gives us some guidelines. Right. Otherwise, I can see our budget people say, how can I even cost this? This could be anything that somebody decides is exceptional. So we would need some ideas there, and we'd be happy to, if you have some ideas before the next meeting that something that you would think would fall within that, maybe that's a way to address your concern.
So Alyssa, we're back to you.
Yes, sorry.
So
yes, and so you had suggested such as. I think I suggested included but not limited to, and I'm not sure which one would be better. But either way, we don't want to make it an exhaustive list. We don't want to unqualify somebody. So, and I had started with the military spouse, but I think you've kind of said that should be in a different area.
I think so. I was thinking more like reductions in force that are outside of the teacher's control and not subject to the teacher's performance. I think we could include teachers.
Before you get much further, I think it just feels like now we've got economic drivers impacting the way in which I'm just not sure that I would agree to reduction in force.
Okay. Well, let me go back to the drawing board to start drafting a list. I think this could reflect our initial conversations about the differences between state certification and
Yes, that
to the
I
extent-
would agree
or
with for
moves,
sure.
Like what happens as you're applying.
I was thinking, and I don't know FMLA well enough, and I don't know total and permanent disability well enough, but an extended sickness, such as maybe cancer, where they've taken a chunk of time off work to undergo. I don't want all that verbiage in there. I'm just trying to describe the situation
Medical.
for which.
I mean, medical.
That was one thing that I had thought about would
That
be
is
in here.
covered in the FMLA.
Okay.
Yeah.
All right, I wasn't sure if that was in FMLA or not, so.
It's very broad in the language, in the application for suspension.
So if it's already there, then we don't need it, but.
But I would agree, if it's already in the form that we're using, then we don't necessarily need the language here.
I was gonna
But
echo
I
that.
do think- I'm sorry. I don't think we need it here if it's in the form, but I do think specific to military spouses, especially with some of the information Stephen gave us earlier, that we should go back to the drawing board and make sure that we can find a place for that parses out close to the actual indicator for military service.
Yeah, it's just, I think we're trying to thread a needle here where right now, for example, the department couldn't suspend service because of a natural disaster. And so they have to come through this whole process, though obviously they're not making this one little change, but have to go through this entire process to add something that I think is pretty common sense. So where we can sort of help the department out and the service are out, they don't want to be making these decisions either that adversely impact these teachers, but also is narrow enough at the same time.
To that point, as I'm sitting here thinking, is this something where if there were these extenuating circumstances, the student could reach out to the ombudsman of the department at FSA and bring up something like this? I just don't, it's been a while since I've had student loans, so.
That was kind of why I asked the question, would they now grant the suspension based on a natural disaster? And they said that they couldn't, so that's why.
So it's not something that you could route. I'm thinking of outside of this particular one that they've put in there. If there are these extenuating circumstances, we're all trying to rack our brains about all the different ways that could emerge. Is that something that could go through the FSA Ombudsman office? And it sounds like the answer is probably no.
I just had to check something on my desktop, and I needed to take it out for a second.
Don't worry, we're not writing anything anyway.
Just in
Poor Aaron.
clarifying. Just in clarifying. Well, I was saying maybe under the national disaster or other similar circumstances.
Even residing or being employed in a federally declared major disaster area. How long does that last? If you live in a major disaster area, unfortunately I have not reviewed this cross-listing yet, but I will. How long does that last? So, like thinking about Hurricane Katrina down Louisiana, how long was New Orleans registered as a natural disaster, and how long would that suspension have lasted?
It's a FEMA question.
Yeah.
They're right across the street. So
But I would say over the last few years, I think the department has proved to be pretty flexible on some of the disaster guidance that they've put out in a lot of these cases.
And so the question then becomes, should we tie it to that and or similar circumstances for, if we tied it to the what is going to be added anyway regarding the national disaster, is that 4? That maybe we should tie, or other similar circumstances. Would that be too broad as well?
What would be another similar circumstance? I would just ask that question, play devil's advocate.
I think, again, what we're looking for is just, we've been very specific here, and that doesn't necessarily address unforeseen situations, and we're just looking to make sure that As it relates to suspension of service, again, my intent is that someone still be able to fulfill their obligation so that they don't end up being moved into another category. And how we can do that, I think, is through suspension. But I think we also need to be at least clear as to what it would be so that others taking note and or wanting to do this well or fulfill their obligation know exactly what they are getting into. I'm not for sure. I don't want it to be more cumbersome. I would like to make it less cumbersome.
So one thing that I just thought of while trying to come up with extenuating circumstances was we had a school in Erie that burned down. So I don't think currently those teachers would be able to receive a suspension unless we had something that they could ping on this list. And it's not there currently.
It wasn't a disaster.
It wasn't, yeah, we didn't declare it a disaster or anything. It was just unfortunate.
Yeah, I don't want to give too many particulars, but another example is, in the Buffalo area, a plane landed on a house. So again, that's not a federal disaster, but that significantly impacted the people in the plane and in the house. And so, but that would that be covered in anywhere here? No. Right. So, but the thing is, those are very particular examples in both instances.
So I would recommend the committee think about language that, might be able to cover these more specifically rather than super broad, because it's very difficult to, somebody has to decide at some point what that is, exceptional, for instance. So how would you make that consistent across situations without having some sort of definition for it? So we're just trying to think of a way to make it really doable so that everybody would understand what it is, it's consistent for everybody, and take that language back and then see how people feel about it on the other end. Because that's a recommendation on our part.
I would also mention, as Brian said, it has to be something we can document. So like the school burning down, you can say that the teacher taught here, the school burned down. The airline and the house, I lived here or I was on this flight and this happened. So to get to something that's very vague, we have to also consider the burden upon the grant recipient to prove that this was them, because you can't just leave it wide open and they come in and just make a statement, because that puts too much, it's too gray. And so I think we just have to make sure that it's something that can be documented. It's not very vague.
I can also look for examples in some of the other department regulations. I just don't have them immediately available right now. But I also, from the examples that you raised, and thinking of like if a teacher impacted by 9/11 moved, and then needed to find a job as a side effect of 9/11, we'd want them to be included, potentially impacting a larger group of teachers. I mean, there are other situations.
And some of that would be caught up in, that was considered a disaster from the federal and congressional
that's true. Okay.
So.
And I'm just going to throw this out there. I'm not even sure where I'm at with it. But one thing that I do know that disrupts a teacher's work schedule could be a strike. And that individual teacher may not have a whole lot of control over that. Again, I'm not sure that I like that as a reason. It's just something that I know would cause them to pause their service.
I think then we'd have to get into sort of the more, like, did that really prevent them from doing their year of service? So not just saying a teacher strike, because remember, they have to certify that they did their year of service. And perhaps I'm just naive here, but I don't think that somebody would say because teachers went on strike for a couple of weeks that they didn't complete their full service.
Oh yeah, I don't think they'd even have a difficult time getting the form completed by administration, because they always make up the hours and everything to keep it within the
correct
state statutes and stuff.
I'm just trying to think of things where this really does stop a teacher from being able to complete their service. Something that is so much that the person filling out the form would be like, yeah, you know, of course you did this type of thing. Check, check, check. So what would drag us out of that?
So I wonder, would this be a possibility to say, or other incapacitating circumstances? Would that be sufficient?
What is an incapacitating I'm sorry, I have to be the
Or a
devil's.
circumstance which prevents the teacher from teaching for a prolonged period of time due to circumstances out of their control. Yeah, I mean, something to that effect. But I would also say, as we're queuing up for the dispute process, the strike question does add an interesting question, because if a principal refuses to sign a form in retribution for a teacher being perceived to be part of a strike, that would be something I would want to be included within the dispute, whatever dispute process we arrive at.
So I have just to maybe tie up one small thing, I have a suggestion for the spousal language, if we want to mess with that for the moment. And so thinking about it under Romanet 3, immediately following the active duty status language, and we can move it around if someone has strong feeling. But I just have a simple line, spousal relocation as a result of the service described in, and then cite back A13. I don't know if that can be a starting place for our conversation.
I think that's a great idea, and I might in Numerat 3. I wonder. I don't think in order to active duty status, I don't think includes changing duty stations, and so in that regard, it's out of step with. I think it's the SCRA, which allows service members to break leases when they have a change of duty station. And so maybe before the next one, I would just want to check what that language is in the SCRA and make sure it's included, so that way it would be extended to both. Not right now. If we can add a little bubble that just says check the SCRA for their language, that would be great.
We can always revisit, so don't. I mean, we are going to revisit, but I would like to get a first pass through. So, back to 686.42, dischargement of the agreement to serve. Our first changes are in B, total and permanent disability. And I just want to note, I think there might be under where we have the first redlining, if you go a little bit further down. Somebody should check me on this, but I think that, okay, all right, on my copy it's not struck. Never mind. It's okay in here. So what we're doing here is we're amending these regulations. Because this existing regulatory language is obsolete, we're going to amend these. And what we're doing is we're striking out the old language and putting in the new language, which is based now on the current information and in the current procedures that we have for discharging a teach grant service obligation based on the grant recipient's total and permanent disability. So this is the old language that is struck out. And then if you scroll down a little bit more, you can see where we have replaced it with new language. Rather than me reading it out loud, if everybody would just take a look at it and see if you have any questions or concerns. I do want to make one sort of point out, and I'm looking up here and I'm looking down here. If we go to 4, we actually make a note there that the recipient will not be required to pay interest accrued on the teach grant disbursements from the date the agreement to serve was discharged until the date the agreement to serve was reinstated. So I do want to make that notation in case that was.
Could you have, how would the secretary receive information that the student no longer qualified for the disability discharge? I'm asking because there are times when we may have a student that had their loans forgiven for total and permanent disability. They come back to school, they want to borrow, they get a letter from their doctor saying they're no longer disabled. Is that what would trigger it potentially? Because we would want to know that from a counseling perspective.
No, if they're subject to the 3-year post-discharge monitoring period, which applies to everyone except for certain veterans, and they want to get another loan within that 3-year period, they have to get the physician certification, and the loan that was discharged has to be reinstated. The loan could also be reinstated if during that 3-year period we determined that if they qualified based on Social Security by an SSA rating, and we get information indicating that they no longer meet that standard, that could be another reason. But I don't think that there is no process that I'm aware of where we would be for SSA to notify us of that. But if the grant recipient actually must agree to tell us if their rating changes so that they no longer qualify. So if or borrower, I should say. So if they do, that would be another reason for it to be changed back. But once you're past the 3-year monitoring period, then if you want to get another loan, you do have to get the physician certification, but there's no reinstatement of the discharge loan. I don't know if I answered your...
You did. Thank you.
Other comments?
So I just have a question in here, and this is actually for the administration, because under this language about the requirements 3-year period following, and then you have the secretary's notification will, and then it says provide information on how the grant recipient may contact the secretary if the grant recipient has questions about the reinstatement or believes that the agreement to serve was reinstated based on incorrect information. So that sounds like to me there's an appeals process in place for this particular situation, and I'm curious if that appeals process exists now, and then also can it be, do we need to, it's not only there, but use that same appeals process for those who feel that they've been converted incorrectly moving forward? So.
This language here is pretty much verbatim the same language that appears in the loan program regulations, because our intent was if you want to get your teach grant service obligation discharged because you're totally and permanently disabled, to simply follow the procedures that are already in place for the loan programs. So yes, that process is already in place, where if your loan is reinstated and you believe it was based on incorrect information, say it was reinstated because we got information indicating that your earnings from employment exceeded the poverty line threshold, whatever it is, and you say that that's wrong, I didn't really make that much money, where that would be an example of how you could claim that that was reinstated based on incorrect information, and then you'd have to provide the information showing that in fact you did not exceed that threshold.
So, oh, go ahead. Did you want to say? Sorry.
I was just going to say it's not a formal appeals process.
Okay.
It's similar to what we're suggesting farther along in here, more of a reconsideration. There's the information you have that we didn't have, that you believe puts in doubt the correctness of our decision. So it's not a
a formal appeals process,
yeah.
if you will. Okay.
Yeah.
Thank you.
Anything else? Or should we move on?
So I would like to raise that this may be an opportunity to add regulations that address the folks who have already had their grants convert, to do a proportional discharge based on when their grant converted. So thinking of the folks that had their grant convert in 2010, if it's reconverted and they then continue to have a 4-year service obligation, they may be out of the teaching profession entirely at this point. We're now 10 years later. Or nearly 10 years later, when these regulations will go into effect. And so I will be ready to come to the table with draft language. And I would like to propose that to the committee as a potential partial remedy for folks that have already had their grant converted. But I'm curious about your thoughts as I think about that draft language.
So you're thinking of a way in which a teacher or a person had their loan or their grant converted to have another opportunity to serve to.
So I'm saying that for the folks that have already had their Teach grant converted on forms that were not approved by the OMB, right, which would already give them a way to contest the conversion under the Paperwork Reduction Act, subject to, of course, our legal debates. One way of remedying that would be to sort of copy this idea of proportional discharge that's used in the military context, but instead of having it be 3 years of military service, you could say if your grant got converted prior to 2012, there is no more service obligation if your grant gets converted back under the dispute process or an automatic conversion, as I would still propose to the committee. If you got your grant converted in, so that it works out, so that when their time is reinstated, they would still be able to complete the service obligation, and hopefully we would be capturing folks that stayed in the profession.
I see now what you're saying. So somebody who goes through this review process only has maybe 2.5 years of teaching that they can show. They would, based on however many years ago it was, potentially have a reduced from the 4-year commitment, something less than that.
Yes.
I don't know if we can do that.
I was going to say, I'm not sure that it's such a specific issue to be addressed, and I don't think that the regulations are the place to try and remedy that, and I don't think it will survive the muster. I don't think the department will support it, and that I understand the challenge that you're raising and the desire to find a remedy, and I'm not sure that this particular situation, this particular place in regulation, because what's going to come back is people will start challenging, well, why that? Because, 10 years down the road, the service, no offense to anybody in the room, the service still sucks. I got converted wrong. Why are only these people getting the remedy? Why am I, because now it's whoever the servicer is, maybe they recompeted out, that person's still not good. And I think that that's that's looking back in time, and the regulation is about how to proceed forward. And I really feel like this is something where we can put it on the table that we want to come to the department outside of the regulations and figure out a solution, and then pursue it in other avenues as well, where there are other places you can take this that would have the same effect.
I think, unfortunately, this may be one place where we disagree. My constituencies would still say that there should, that at least the main committee should consider the option of a proportional discharge opportunity under these regulations. I hear what you're saying, that it should be forward-looking, but at times regulations also address starting points and ending points, and do address injuries that have occurred in the past. And so, like I said, I'll come to the table with language during our next session, and I welcome your feedback, but this is one of those things that is very important to the folks I'm here on behalf of.
Oh, sure.
So let me.
I represent people who had this happen too, or their students did.
So just so in my understanding, when we're talking about conversion and error, I think that's largely about paperwork errors. It's not about lack of creditable service. And so unless someone would make the claim that because it was converted, they had to stop teaching, I would not be in support of what you're saying, because what the conversion was not an injury to you continuing as a teacher. That's my initial thinking about it.
So I will say I have heard from teachers who could not continue in a high need position in a low income school because they couldn't shoulder the loan payments. So, and I understand they may have access to things like IBR. There are a number of reasons you wouldn't take, so income-based repayment, there are a number of reasons you wouldn't take advantage of income-based repayment as well. And so, and also when we talk about servicer issues and paperwork issues, I believe my understanding of one of the department's solutions, even for the roughly 25,000 folks who had their grants convert purely due to servicer error, not due to their own paperwork submission issue. Although I would, just a brief tangent, I would assume that there are thousands of people who are in the like paperwork submission conversion category. That they are now going to have their service obligation potentially reinstated, and I would want it proportionally reduced, just to reflect the timing of when all of this stuff happened. And given that I have seen that there have been folks that have been forced out of qualifying positions because now they have loan payments they didn't expect.
I guess I just wouldn't want, again, on first thinking about it, I would not be supportive of an automatic applied to all, because it sounds like very particular circumstances in which that might need to be considered, but not as an automatic, this applies to all.
Question for, and we may have covered this earlier, I apologize. How far back is the department looking or going with their call that they have, that if you felt that you were converted in error due to these things, that we're going to reassess your whole situation?
I don't believe there's any limit, although there may be, for some of the people who are serviced by ACS, there may be some limitations on the records that we have available to identify those people, but that would be the limitation.
So all the way back to the beginning of the
so all the way back to the beginning of the program.
I believe so,
essence.
but again,
Okay.
remember that ACS was the servicer from the beginning until 2013, and some of not all of their records transferred over, and we have limited information available for some of those.
And is there, to this question that you're raising around the service component, if this has happened, is that part of the consideration of I mean, I know you're looking to, are you going to look back at the teaching that they've done, and if there are people who say ended up having to leave the qualifying service, is that under consideration?
Well, we're not talking about extending the 8-year period or we're saying that if you haven't already completed the 4 years, you have to still be able to do it within the 8-year period.
Is there any opportunity to reset that 8-year window? I don't know if we want to. I'm just asking.
Well, I think that our view is we don't really have the authority to do that under the law. That it's 8 years, except for unless there's been a suspension as provided under the regulations.
Can we grant an automatic suspension for any point in time in which their grant was converted to a loan?
Because what if their 8 years is already passed?
So then they get reconverted and converted again.
So someone who 10 years ago did a year of teaching and had their grant converted and they left teaching, they didn't do any more teaching, then they would not be able to, they wouldn't be a candidate because they wouldn't have enough time left in the 8-year period.
But if they were converted in error and left their job because of that, or anyway, they'd have to prove it. I mean, they'd have to prove it. But if they left their job because of that, and it was 10 years ago, because it could be 10 at this point, 10 years ago, then reinstating their 8-year, I mean, just picking up where their 8-year clock started.
Well, that's beyond the scope of what we're doing now. We're addressing people who either completed all 4 years or they maybe completed some of it and intend to satisfy the remaining portion and would be able to do so within the 8-year period.
But well, wait a second. I do respectfully disagree, though, because this could be one of the enumerated exceptional circumstances that we were discussing when we were talking about the department's discretion to issue a suspension. So we could include this category of people that have had their grants converted in error as an exceptional circumstance that would warrant suspension.
Yeah, I think it makes sense to allow for a suspension during the time frame that your grant was converted into a loan. It just makes sense.
And I think we're talking about that very specific group of people who then left teaching because of this, or left teaching in a
I don't think
at
we
the
need
high
to.
needs.
I'm not to interrupt you, but I don't think we need to limit it to people who left. I think we could grant the suspension for any time frame with which your grant was converted to a loan.
Because
no matter why,
they would have to choose. Because if they were granted the suspension, the years they were teaching during that time cannot count.
So with the
Right.
exception of voluntary conversion.
But can we clarify though? I don't understand why, if you have a suspension, which you may take out because you're expecting that you're going to be out on maternity leave or whatnot, you end up coming back early. I did not read the granting of a suspension clock as still as preventing the department to consider those years that you may have worked even while being granted a suspension. I don't think this suspension forces you out of having qualifying service years in the same way the department has read that you can have concurrent service obligations. So
I would agree.
So I don't think
I'm going to disagree because I think you can't have both.
Right.
Like if my clock is ticking, then I count the years. If my clock is not ticking, I can't count the years.
But why can't you have both? I mean, think about it. The whole reason for the suspension is because you have something that is a significant impediment. So you should be able to, because you're facing an impediment that not everyone else faces. If you need the exception and you don't take advantage of it because you overcame that impediment, if anything, you are even more exceptional. And yes, I want to give you your credit.
Well, then restart my clock.
Well, yes.
That's where I start to wonder
in a
where.
Case, I'm getting confused and not even sure I understand anymore how this relates to this. But if you applied for a suspension, but maybe because you had a health condition or something, but you recovered and you went back to teaching, and the suspension is still in effect. As you were saying, you can't, if the clock is stopped, you can't get credit for service while your service obligation period is no longer in effect. However, you can have that suspension removed so that you then get credit for the teaching, and that would also restore your eligibility because there's a 3-year limit on the suspension. So those situations are taken care of, but these are not common. But so there are remedies for that right now.
As I said, that's not. While I understand that is the way it currently functions, that is not my interpretation under the statute of what the department can do. And so I would suggest that maybe we as a committee look back at the regulations and look back at the statute and then consider proposing that option as an option to the main committee as a potential solution. Understanding that there's a difference of perspective about that.
Let's move on to our.
5:12, do you want to start something else?
No, I just want to finish off this one section. It's one little thing.
Okay, that's fine. I just wasn't sure where you were.
Yeah, it's just the one little addition we've made under military discharge, all the way down where you can see that we have added, to be consistent with existing language, a reserve component of the armed forces named in 10 U.S.C. 10101 or the National Guard. So this is just expanding on the meaning of armed forces.
Do we want to add a similar military spouse exception for folks who are stationed overseas and?
Well, this is kind of.
I don't think we can. Yeah, and it's a discharge for service.
It's letting go of all the service and the service.
So I could have potentially my grant obligation because my husband would be serving overseas. That doesn't.
So yes, I understand that it's an exchange for military service. However, what I'm asking is should it be similar to our suspension provision that if you are a military spouse who is now stationed with your family overseas. It's not, so I am part of the military spouse community, and so it's thinking of the families that do have to serve abroad. I don't know how military schools would qualify, and I don't think they would qualify as high-need positions. So that spouse would then have no ability to fulfill the obligation if they're overseas in Okinawa for 8 years. Should that spouse have known at the start of being stationed there that their stationing could have extended out to 8 years and that she should have voluntarily converted early? She or he. Like, that's what I'm saying. I mean,
even in this language, it's a gradation based on the number of years for the amount of discharge that you get, and it's because of the active duty status.
So folks that are stationed abroad would also would be considered in active duty. And I think the active, if I'm understanding the way that this was originally drafted, it looks like it was almost intended to cover folks who are in the reserves as opposed to which is just something to think about even as we go through the earlier revision, and not military spouses or military folks that are serving 2 jobs that somehow they've managed, and I don't know how they would manage to do it, but to stay employed as a teacher while simultaneously serving like enlisted active duty. Yeah.
If we are going to add the spousal consideration, I could only agree to that if it is with a relocation, because I don't think the spousal agreement to serve should be discharged if my spouse goes overseas. And that's the way I read it if we just throw it in there. So we would have to make sure that we get very clear language to say that it's a mandatory move. And I don't know that the military makes a mandatory move.
I don't know if it needs to be a mandatory move, but we want to keep families together, right? And so if they are stationed for 5 years in overseas, and a spouse would want to teach in a DOD type setting, it would not meet what we've said so far. The suspension might cover them, but in some cases, because of the terms of service, I mean, we've been in Iraq and some of these places for almost 10 years now. It might exceed the suspension requirements. I don't know how prevalent any of this is. That wasn't something I had considered before. And so I was hoping that the suspension would cover most of what I was looking at. But I do think there might be a circumstance in which someone might go beyond the 3 years.
So not to interrupt, but it is noon. How about think about it over lunch, and when we reconvene, we will try to put this point in some sort of context, and we'll see what people want to do with it, and then move on to other matters. So have a nice lunch, and we'll see you at 1:15.